thanks, Wendy, for coming on and sharing your time with
You're
us.
welcome. Good to be here.
So tell us just a little bit about like what does an estate planning attorney do, and kind of, if you want, how did you get started and things of that sort.
So essentially, I think that the job of an estate planning attorney is really to meet with the client. I mean, nowadays we have ways phone and virtual and things like that, but really to get to know their client so that they can understand what are the family dynamics of that client, what are the assets of that client, what other issues maybe do they have in their backgrounds, that things that are important to them. For some people, charitable, contributions are important. For some people, protecting a legacy for their children, is important. So I think the job of an estate planning attorney is to get to know their clients. And then in doing that, figure out, there's no one set of documents that is going to be, a fix all or the proper set of documents for any particular client. And so some people, and we'll talk about this more, I'm sure, later, but might be well served by a will. Somebody else might be well served by a trust. Families that have only one child may be able to avail themselves of some different types of documents that people that have six children, that might not be the best fit for them. People that have young children, obviously there may be needs to, consider what kind of trust will take care of their assets until they're old enough to manage them themselves. Whereas if all of your children are over 40, then that might be, a different type of document for you. So I think overall, the job of the estate planning attorney is going to be to get to know the client, get to know the fact pattern and their background, and then for them help to create a set of documents that is going to meet all of their goals, in the future, protect the family, have those specific like permission slips in place for people to be able to help them if they are, incapacitated, unconscious, things like that. So
Yeah.
I think that's the overall goal of the estate planning, consultation, relationship, with the attorney.
Yeah. And it's really like, it's like anything, right? It's like finding out about your client, understanding them and like helping them specific. I think sometimes if we aren't aware of what you guys do, sometimes we look at either our friends or family members and we're like, we almost like draw from, oh, this is what you did. This is what I need versus what do I want specific for me and my family. And then, doing that.
Yeah, I can't tell you how many times someone will come in and they'll say, my friend, got this transfer on death deed, and this is a great idea for me, and I need it. And then I say to them, you have four children; they're all under the age of 12. That would be the most horrible thing you could possibly think of doing. Or they've already gotten that document off of the internet, and they've completed it and they filed it with the deed records and done, so those are the types of things I think that we are able to research so many things on the internet. And I think that's a great way to get started to think about what your decisions might be. But then to turn around and then go to a professional. It's just like maybe I don't feel well and I'm looking up what the symptoms could mean, but I don't use Google as a substitute for going for a consultation with my doctor, or a therapist or whatever type of attention that I might need, my provider. I don't just use the internet.
Yeah. Yeah, totally. It's like it's good for knowledge, good for maybe pondering thinking, but then like you say, like take those questions. So, do you have on your website or like where would you suggest for people to like, because I think a lot of times too people come in and they're like I don't know what I don't know, and so it's almost like this, and emotionally, right? Like it's an overwhelming thing of like, where do we even begin and start? And so, what do you typically suggest for clients if they are like at the beginning stages, as to like what, where do you even go for information and things of that sort?
So we definitely on, our website, which is the heritagelawtx.com. So we are based in Texas. We do have just this like an overall kind of estate planning brochure, which would just go over some of the general documents that a lot of people are going to need in Texas. Obviously in different states, there's going to be different documents that or different names. Sometimes they are named a little bit different, in different states. But also something that I find that people don't really necessarily do before they come in and that would be really helpful is to have a list of what your assets are. I
Mm.
mean, they come in and like, well, we have that one account over there. Do we still have that retirement account? And then when we moved here, we quit going to that thing. And so, really, whether it's you're an individual and you're handling all your own finances or you're a couple, really going over, what assets do we have? Do we both even know what they are if we're two of us? Because somebody might have
Which
an IRA over here.
a lot of people
And
don't,
somebody might
you
have
know?
a 401k over there, so that's a big thing to just do before you even get to the attorney. And then also just having a complete listing of all of your children's, names, dates of birth, addresses, phone numbers if they're, adults, that kind of thing. But then, like I said, on our website, there'll be some general information to at least sort of say what are some options that we have. And then, of course, as you come in to meet with an attorney, they should be going over with you all the different options of things that you could use during your lifetime. So, powers of attorney, those are our permission slips. If I become unconscious and I need a medical decision made for me, most states are going to say, no one's allowed to do that until you have that permission slip in place or that power of attorney in place appointing, that person.
Yeah.
If I'm older and I have an adult child, who's to say whether it's supposed to be my spouse, who may or may not be the parent of that adult child, or it's supposed to be my adult child who's going to be in charge of making my medical decision.
Mm.
So I want to make sure, that there's no confusion. Here's person number one. Here's potentially, an alternate for that. And so there's, powers of attorney that are for medical. There's going to be on almost every state powers of attorney that are for more of our business or financial affairs. So again, if I either need assistance or I am completely incapacitated, somebody still has to file my tax returns.
Yeah.
Somebody still has to pay my utility bill that makes sure that my house, is still got, electric, air, all those kinds of things, water. So I want to not have that be a guessing game.
Yeah.
And I definitely don't want to have that be dictated by a court, because without those permission slips in place, then the people that care about you are going to have to go to court and file for a guardianship to be put in charge of you and spend thousands of dollars doing that in most states, post bonds, potentially appraise all your property, file yearly accountings for you. So, as well as, I mean, obviously, we want to talk about what would happen to our assets in the event of death, but we also want to plan for incapacity or even brief incapacity during lifetime.
Yeah.
So,
And sometimes those people aren't the same people, right? Like, so you could have a medical power of attorney, right? And then you could have a financial power of attorney because they, that person doesn't want to do the medical or vice versa or whatever. And so just,
yes.
you know,
Yes, and that's even true for it. Like if it is a couple, for example, doing the planning as well, each person is going to pick their own people. So most of the time with a spouse, I'm going to say my number one decision maker, if I can't do it for myself, might be my spouse. But then my alternate might be my sister is a nurse, and I really trust her, to make a medical decision for me. Well, my husband may say, well, his number two person is again possibly his nephew who is an EMT, and he wants that person. And then again, you may have that, one relative who, they're the CPA or the financial planner. And so when it comes to in Texas, the statutory durable power of attorney, then I may want to pick that person because I want that person to be in charge of my finances, my more business decisions, and they're more, geared toward or suited toward being the power of attorney for financial. And I may want to pick somebody different, like you said, for medical, because everybody has different talents that we can, hopefully borrow when we need to.
yeah.
So,
So in terms of, because you said that you're in Texas, and so as far as like hiring an attorney, obviously most of the time, would you say that you probably typically go to someone local or someone, that someone has referred to you and they are local, but is it like, CPAs don't have like, they can be, or like financial planners are licensed in specific states. Is that the same way that it is for attorneys as well?
yes. And so you would definitely want to have an attorney in the state where you reside. Something to also, though, be aware of is if you own property in multiple states, then that may be that I need to consult with an attorney in the state where my primary residence is located. But then I may have a little, side consultation with an attorney where my potentially vacation property is located in a different state, because those state laws, can be different state to state. So I get people coming in all the time in Texas and they're like, oh my gosh, I have to have a living trust. I've heard about how horrible probate is and all these things. And they're reading an article from California. And so they've gotten all up and, terrified about, what's going to happen to them. And, I'm able to say, well, the good news is you don't need to be that terrified. Texas has a really easy probate system if we ask for that in your documents. And we can still talk about a living trust if that's still something that's important to you. But what you're reading is something out of New York or Florida or California. And so that is why it's important to not, again, yes, you can do some research on the internet, but first of all, make sure you're reading something from the state where you live or own property is a good start. And then also consulting with somebody licensed in that particular state where you live. I like to have my final meeting with my clients potentially in my office if at all possible, because one of the things that we also want to be really careful of, you can have great documents, but if you don't witness and notarize those documents correctly, I have had people, and I hate it, but the person who's done the documents has already even passed, and they bring them in. They're like, this is their will. See, it's notarized. And I say, well, in Texas, it needs two witnesses. That's only one witness. A notary is one witness. And a really good will in Texas is going to have two witnesses and a notary. And so they think that they're holding in their hand a will, and they do not have a will.
Wow.
So that is, again, and even when people get a legal Zoom document and they're like, well, it was a Texas, legal Zoom document. And then they had, one of the beneficiaries be the witness. And now the gift to that beneficiary is void.
Yeah.
Because that's not allowed, So there are things that even though, you think you're doing the right thing, I always tell people, you know what, I wouldn't, if I had some kind of criminal matter, which I hope I never do, but I wouldn't trust my freedom, my, potential, future to something I read on the internet. I would go get a professional, and have them to help me get through that situation, because that's not something that, I hope I ever have to do, but that I have any experience in.
Yeah.
So
Totally. It comes from a genuine place, I think, right? Like we want to know, we want to be informed. And also there's so much information and misinformation on the internet that, you already come in with an idea of what you think you need to have or whatever, versus like just coming in with an open mind and being like, this is our situation, like just kind of giving you the facts. And then you get to be like, okay, based on this and this and this and this is what I would recommend. And then this is how we do this. And,
right. Exactly.
Yeah.
Yeah.
So can we dive into a little bit about wills and trusts? Because you have made comments about that. Like not everybody, because I do think, it kind of gets, I don't know if it's highlighted or, piece. It's kind of like not keeping up with the Joneses, but it's like, oh, well, so-and-so has a living trust, so I need one, versus like what actually are the two differences? And then why would someone want a trust and why would someone maybe not want one? Or maybe not at this moment in time, but as they grow assets or evolve, things of that sort.
So in order to really understand the difference between sort of wills and trusts, we have to also talk about the different types of property that you would have upon passing. So when someone passes, we would sort of delineate their property as two different types. One is what we're going to call non-probate assets, meaning we don't need a will, we don't need to talk to a court, we don't need a document that I wrote to deal with that asset, versus a probate asset, which means we're going to look to some writing of mine or some court or something to deal with that asset. So when I have a life insurance policy, if I pay $100 a month to MetLife for 20 years and I have a $100,000 life insurance policy, when I sign the form, the beneficiary designation form for that policy, I have now made that policy a non-probate asset. They don't care whether I have a will. They don't care whether I have a trust. They are going to follow the contract that I made with that company in order to distribute that asset upon my passing. So we have a lot of things in almost every state that you could make into a non-probate asset. So if I go into the bank and I open a joint checking account with my husband and we sign the signature cards a certain way, it'll say this is a joint account with right of survivorship. So you'll see sometimes JWROS on your bank statement. So that means if one of us passes, the other one just owns that account. They don't care if I have a will. They don't care if I have a trust. They don't care what I have. So what we are doing when we are writing a will is we are saying what happens to my non-probate asset, or excuse me, my probate assets upon my passing. So things that are probate assets, cars, houses, household goods, bank accounts that don't have a beneficiary, an IRA that doesn't have a beneficiary, an investment account that doesn't have a beneficiary. Those are the kinds of things that they're going to say, hey, what did Wendi say happens to this when she passes? So when we write a will in Texas, that will is a piece of paper until it is approved by the court. And so that word probate is just really, it's a scary word, but it really just means approved. It means the court has approved this piece of paper that I brought to them and has said to them, said to the world, this is a will. And, it's now
valid,
proved
it's legit.
it's valid. Right.
Yeah.
So when someone passes, the way you kind of get into probate is it's like, okay, grandma passed. She has an account with Bank of America. There's no beneficiary. And I bring to Bank of America this will, and I say, this is grandma's will, and it says I'm the beneficiary. And Bank of America, they're like, we don't want to be responsible for knowing if that thing is, paper, whatever is altered, or, is it real? Does it meet the Texas requirements? Because Bank of America is a national bank. You could live in one of 50 states and have, Bank of America. So the court says, we file that will for probate for the court to approve it and probate it, and then we take it to Bank of America, and then Bank of America will release that to the executor named in the will. So when I write a will, I'm nominating my executor, but the court is going to appoint my executor. And so that is what we do when we probate. That's a very simplified version, but we're basically having to go to court. Typically, you're going to have to go to court. In Texas, we have a very easy probate system called an independent administration of the estate if you ask for it in the will. So again, if I want to have a will, I want it to be written in a way to avail myself of the easiest process possible. No bonds, no appraisals. I mean, whatever the house is worth on the open market is what the house is worth on the open market. I don't need to go pay a bunch of people to appraise that, And so that is just something that we, want to make sure we're doing in the will. So the trust. So the difference between having a will, which would be potentially needing to be probated, and having a trust. So when I create a trust, my analogy is that I sort of create a container that is holding my property. It's not being held in the name of Wendi Lester Efflandt. It's being held in the name of the Efflandt Family Trust, or whatever I might want to name this trust. So I use the analogy when I'm talking to people of having a wagon. I have created this wagon. And so instead of carrying my property in Wendi's name, I'm going to carry it in the Efflandt wagon. And so when I write a trust agreement, I am giving the rules of what I want to have happen in that wagon. But then what I have to do is I have to actually put all my property into the wagon. And so I have to transfer, I have to deed. If I have a house, it needs to be deeded to that trust. If I have bank accounts, they either need to be titled in the name of that trust, or again, a beneficiary designation to that wagon. So then what happens is, as the trustee of my trust, I've appointed myself as the trustee. I am the wagon puller, right? So I'm in charge of that wagon. I can put things in, take things out, usually with a revocable or living trust. That's a term you'll see. It means I can change my mind. I can take things in. I can, change the terms of my agreement during my lifetime. It's very flexible. But at the end of the day, when Wendi passes and she was the trustee, it really doesn't make any difference, because everything's not in Wendi's name. It's in the name of the wagon. And so then a new trustee, which I've appointed in my documents, steps up and they become, the driver of that wagon. And then they can disperse, to my different beneficiaries that I've designated in advance in writing, the property that was in that wagon. And so there usually is not any kind of a probate, because I've taken the property out of being probate assets by placing it in a trust.
Do
So
you
that's kind of the difference.
do you find that people want to have co-trustees of the trust, like, and that, and when I say co-trustees, yes, not necessarily upon when they're living, but like, okay, when I pass, then I want two people to manage this, whatever's left, disperse it and things of that sort, like,
Yeah.
you know
Well, so I have people ask for that a lot,
okay.
and I tell people no a
Okay,
lot.
that's what I'm saying, like,
Um,
tell us.
and
Yes.
so they'll say, "Oh, my 2 kids, and
Yes.
I want them to do it because I have to." And so what I tell people, when in the world of executor and trustee, it's not an either or. It is typically a both and. So, if you appoint 2 people as executor, co, 2 people as trustee, co, they, first of all, have to be unanimous. So you better make sure that they are always going to decide together, and not disagree, which, could be a problem. Number two, in the attorney world, I typically have to make almost, 2 of everything. They both have to hire the real estate agent if there's a house. They both have to go to the closing. I mean, one of them may live in Kansas and
Yeah.
one of them may live in Oklahoma, or wherever. So, you need to be practical about who you're picking. And people are always telling me, "Oh, I have to be fair and I have to be whatever." And I'm like, choose your agents by their talents. And honestly, by the time that they're acting, you're probably not here anyway. So if they're mad about it, they can just be mad about it.
Yeah.
But in an attorney situation, it's also difficult because then they're both hiring me potentially. And if one of them is calling to ask a question, I really need to be conferencing in the other one, even to have a simple conversation, because I don't want that executor calling the other one saying, "Well, what the attorney told me," and I'm having this whole entire private conversation with, one executor or trustee, whichever way you've done it, and not the other one.
Yeah.
And so for an attorney, it can also be difficult, especially if those two clients somehow don't get along or disagree.
Yeah.
I may even have to say, "I can't represent either one of you because there's a conflict."
Yeah.
So I recommend, of course, that now with a husband and wife, they will typically be co-trustees of their living trust together.
Yeah.
But you guys are already in it for the long haul and having to make decisions together if you're married anyway. So that's different. But then upon the death of the surviving spouse, then I would typically recommend just the most, responsible and trusted and financially minded person to be number one. And then we can have alternates. And if that first person doesn't want to do it, or isn't, life circumstances are such that they're not in a position to do it, they can certainly waive their right, to do
Yeah.
that. So those are some options. But I do get a lot of people, "I want to have it all 3 of my kids be co-trustees." And I'm thinking, this is
And
a,
maybe it's a generational thing, but that's what I have found too, is like a lot of the, you know, my parents' generation is like, well, I want to be fair, like that word of fair. It's like fair doesn't really exist. It's just judgment, like somebody could
mhm,
think that's totally fair and someone else could think that that's not fair, And so that
yeah.
trying to be inclusive versus like, but what is the most like simplest, least, time, most effective thing? And like you say, like having one person, because yeah, sometimes it doesn't necessarily always, and sometimes we can't even agree on like where to go eat. Like now you're trying to decide, all of these. Although, would you say though, yes, definitely only having one person, but when you decide what you want and how you want your assets to be distributed, where would the conflict come in if you did have a co-trustee or co-executor?
I think sometimes the conflict does come in, just with what we call the administration
Okay.
of the assets. And so, typically there's going to be a house that
Okay.
someone owns. And it, like I said, one person wants to hire their buddy who's a realtor over here, and the other person wants to hire, a different one. Or we don't agree on the list price, or one of them says, "You know what, like, let's do a quick sale, let's lower this price," and the other one's saying, "Well, I don't want to lower the price because we could get more," so just there can be, I mean, like, when should the house be sold? Should the house be
Mhm.
sold? Or all kinds of other, what attorney should we hire? Like, if we need an administration, I mean, even to that extent, it's just, there's lots of different things that could potentially arise. Like, should we replace the carpet before
Yeah.
we put it on the
Yep.
market, or just sell it as is? And so those are the kinds of things where if you pick somebody that you trust to be, honest and be responsible, then let them do that legwork, and then let them just divide the proceeds,
Yeah.
when you get to that point. And I tell people when they do hire me, if they are the administrator, executor, or trustee, I'm happy to copy your, siblings
Yeah.
on, we want to provide information. It's not a big secret.
Yeah.
So, the more information that they provide, then that's helpful to the others to know, oh, here's the process and this is where we are. And yep, we haven't, whatever, we haven't gone to court yet, or, that kind of thing.
Good people.
So I always like to provide a lot of information, but it's not a three-way joint decision making.
Yeah. As I was saying that, I was like, oh my goodness, like thinking even about even just because, okay, distribute my assets, like you're saying, the house, but also like when to sell my stocks and all of that. Like it's not just like, okay, this is all that I have and divvy it up. It's like when to sell and all of that versus like what you're saying is like just one person does the deal and then it makes it so much easier. So in terms of because you are in Texas and we talked about different in different states, are there different when laws because is there a federal estate planning tax? And then is that like tell me a little bit more,
Yeah,
about is
sure.
it yeah.
So currently, and I do want to just give the kind of disclosure that,
Yes.
obviously I'm not providing any specific legal advice to anyone
Yes.
that's watching this, because they need to have their own special session to figure out what applies to them.
Yep.
But the federal estate tax exemption currently is about $13.6 million per person.
Okay.
And so most of us are not blessed enough at this point to have to be worried about federal estate taxes. Now, Texas, we do not have a state inheritance tax, just like we do not have a state income tax. Now, there are many states where there is a state income tax and also a state inheritance tax. So right now, I'm working on a state, in personal life that's out of Massachusetts, and it's my understanding that in that state, um, every estate under $2 million is not taxable, but estates over $2 million have state inheritance tax, not federal, but state. And so that's again why you would want to talk to a professional in your state, because where most people in Texas are not having to do very much, estate tax planning because their estates are not going to rise over $27 million. Then that's different from somebody who may be in Massachusetts and they already have a $2.7 million estate. Then they may want to have some more, talk about where do we think our estate's going to be, years from now, and I mean with the financial planning and that kind of thing. So that's definitely something to talk about. They are talking about the estate tax exemption lowering. Congress, they've passed different laws to sunset, I think is what they call it, the estate tax exemption. I believe it's supposed to go down to about $5 million per person. In my experience over the last 25 years of practice, they always wait till the last minute and then change it, and then it's gone up. It's consistently gone up since 1998. So it was about $500,000 in 1998. So you can see, I
Yeah.
mean, it keeps going up.
Yeah.
But all that to say, definitely, I mean, talk to your, CPA, talk to an estate planning professional in your state, because you want to make sure that you are doing the best that you can to avoid, having estate taxes. And sometimes the valuation of assets upon somebody's passing, all of that kind of stuff can help to reduce any potential, for estate taxes, inheritance taxes. So
Yeah. Yeah, I feel like a lot of times it comes from a fear-based place, like you're saying, it's like Congress is like changing it. It's like, hurry up. It's just like Wendy says, like go reach out to somebody that's local for you that knows your state, knows, what your situation is. But yeah, I think so much of I say the financial industry, but like it's such a like do this from a fear base versus like No, I love myself. I love my family. I want to make sure that they are taken care of and that they don't have to figure this out when I pass away. And this is what I want to do for them, you know?
Yeah. And that's
Um,
another thing too that I wanted to just mention since
yeah,
we were talking about state laws
yeah.
is there are people that are super surprised by what the actual intestate succession laws are in their state.
Okay.
And so I think that, when we create, whether it's a will or whether it's a trust, but I just tell people you are picking your beneficiaries and you are making a plan, because if you don't make a plan, the state is going to make one for you. And that plan that the state makes, it is not always what people expect. And they are super unhappy when they get to my office and someone has, unfortunately, you're already in the midst of somebody unexpectedly potentially passing away, which is one of the reasons maybe they don't have already a plan in place. And then on top of that, they're getting news that they thought that they owned that partner's half of their house and they're now co-owner in their house with some adult children of that spouse that aren't theirs. And that's not making people really happy. So that's again another reason why to just to talk to a professional and make a plan for either yourself, or if you have a partner or spouse, that you're making it with them so that you don't get an unexpected result that is really, a financial disaster potentially for certain people, or it creates a family, division, or it creates chaos
Yeah.
because they haven't planned for themselves, and now this law is different. And again, because even between our states, like I said, just recently dealing with this estate in Massachusetts had no will, and I was really surprised that some of their intestate succession rules were different than what I had
Mm,
seen, here.
yeah.
A big thing to check in your state is, in Texas, people are super surprised when I say that just because a husband and wife both have their name on a deed to the house, if one or the other passes, the other one does not automatically own the house.
Mm.
And they are just shocked beyond belief they literally are like, I don't believe you. I'm going to go look it up. I'm going to go talk to the title company, and there are things we can do to create that survivorship.
Yeah.
But on a deed that just says, John and Jane Doe, husband and wife, that is not what the result is going to be.
Mm,
So if that's what we want the result to
yeah.
be, then we need to put some documents in place to make that happen. So even just that, like being uninformed, they're like, I don't need a will because both of our names are on the house. And that's not what happens automatically. So we do need some of those documents, and we want to have those before we get into a surprise and, you know,
Yeah.
not have that in place. And then the result is not what we wanted.
Yeah.
So
I always say we have a plan, we have an estate plan, whether you've actually done it or you haven't done it. Like it's like either the outcome is because of what you've decided to do and take action on it, or like you said, with intestate, which means you have no will, you have nothing set up, then the court will take care of that for you. And like you said, it's not necessarily in ways that you even know or that the end result is what you actually wanted. So um
and it's just so much more costly that way too. I
oh
mean,
yeah.
so it just adds insult to injury because there's no will, it's not going the way they want, and then also this whole process has a thousands of dollar price tag to get, something that they didn't want even to start with. And so
Yeah.
it's just I hate when that happens because by the time they get, to our office, I mean, we're obviously going to do the best that we can to make a difficult situation,
Yeah.
as easy as possible. But I don't have a magic wand,
Yeah. And the emotional
So
side of it, right? Like the emotional toll of going through court. Like I know, like for in Texas, because I don't know about it if I know anybody that's done probate. So like in terms of, and I know it's different in each state, but like what typically is the time frame? Like are we talking like, oh, a month, or we're talking like 6 months to, a year
right.
probably?
Well, and it depends. Does depend, county by county, because some
Yep.
of our courts are more backlogged. But in Williamson County, Texas, where I am, we're just a little north of Austin. We're not Travis, which is a little bit bigger, where Austin is located. But if you've written a will, again, to ask for this really easy administration of the estate and that type of thing, there's some probates that can last as short as 30 days. There are
Okay.
some that can be 60 days. And so, but then again, compared to those with no will, and
Mm.
there's a whole process, and we've got to get witnesses as to that, deceased person's marital and family history. And sometimes we don't know all their marital and family history, and we have to contact all of the heirs. And guess what? Sometimes there's a child that they don't really talk to and they haven't talked to for 20 years, so that can take months and months and months,
Yeah.
without a will. Whereas just depending on the county, there's a few Texas counties that are a little bit, backlogged. And so those would definitely be, again, where you live and what
Yep.
you're doing. You may, like, if you live in a certain county, we might say, we really want to look at a trust because, probates in this county are taking 8 months, and that might
Yeah.
not be something, so again, even where you live, having somebody who, and I would say, and there are lots of estate planners out there, and they're great people, but also potentially having an attorney that also practices in probate.
Mhm.
Because again, I get wills from people that dabble,
Mm.
in estate planning,
Yep.
and they put the three children as co-executors. And the three children are in my office doing the probate, going, which one of us can waive our right? Because we just want the smart girl to do it, our sister, and the, whatever. Other two are saying, let her do it. And
Yeah.
so that to me wasn't written by a probate attorney because they
Mm.
probably would not have written that.
That's a
So
really
that's
good.
also helpful. Yeah.
That's a really good point, because you do see that sometimes there is specificity in law and then practicing, and then you'll see some attorneys that do construction and they do real estate and they do family law, and it's like, and if you don't know the questions to ask, then you think, right, you're getting, all your documents, all your ducks in a row, and then come to find out, like you said, like, oh goodness, this is not what we signed up for. So
Right.
yeah.
Yeah. Yeah. So, and there are cool things that you can do in different types of documents that will help to streamline things but it also depends on, again, your family structure, how old your kids are, how many kids there are, or maybe you don't have kids and maybe charities are your goal. And, so there's definitely different documents to choose to accomplish different goals. But what people will do is read, yeah, I really want to have this transfer on death deed. I heard it was so cool. I saw it on Instagram and I wrote it to, I kid you not, I had a couple come in
I'm
and
like, is
they
this
wrote,
happen? Does this actually happen?
yes, and they wrote a transfer on death deed to their two minor grandchildren. And they were so proud because they were like, this house is going to this grandkid who's 12, and this house is going to this grandkid who were 13. And I said to myself, that is the worst side. I mean, now you have a minor, owning property who's going to need a guardianship. And so, but they read about it and they got a form online, and they even had the really incorrect legal description of their house. But man, they were about to take it down to the Harris County, tax assessor or clerk, or, to file it. So that's again where you just, there are things that could make it so much easier. You just want to make sure that you're, having someone to help you that is experienced and making the right choice, instead of just going, well, I heard this was cool, I'm gonna
Yeah.
go try it.
Yeah, totally. And like
So
Wendy said already, I mean, I didn't put that as a disclaimer, but I typically, like, each of you listening, like, part of the podcast is like to empower you to like ask yourself your own questions and to, like, rely on your own self, and not like, oh, I heard it on Aaron's podcast, and so let me go do the XYZ. Like, do your own research. But the idea that we hear things and then we don't even question, and we just, we're off on
right.
we're off on this. I want to get into, just briefly, if you're okay with it, like digital
Yeah.
assets, because the way that, yeah, times have changed so much. What are your, I guess, thoughts or recommendations, and not recommendations from like, this is what Wendy says, but like, what have you seen with clients that do a lot of, because online businesses and things of that sort now?
Yes. So for sure, in all of and this is again that whole attorneys that are practicing probate have seen like this
Yes.
issue where somebody can't get their 4,000 iTunes songs, or they can't access their Bitcoin, or, whatever. So in all the documents that we draft, we're going to have a specific authority for the executor or the trustee, whatever kind of document that you have, and even your power of attorney, to deal with and access digital assets, passwords, things like that. Because we have just had that influx of everybody's doing something, digitally and that kind of thing. The other thing that we will give to clients, because we're writing all the legal documents, but then we're also trying to empower you in a practical sense of like, here's how to also like make sure that bad things don't happen and everybody has information. And so we have, I mean, and I know it's as simple as like saying, oh, like writing down your passwords. And I know that we, change our passwords every 2 weeks because they make us on the Sprint account or the T-Mobile or, whatever. But I mean, some of the biggest things are the password that opens your cell phone,
Mm.
the password that opens your laptop, because if they can't even get into those two things, they're really not going to get anywhere. Things like the security code to our front door. If we have all of our documents that are somewhere, so we give our clients like a little location of important documents worksheet.
Yep.
And in that, it has not only like, hey, where do I keep important things like my birth certificate? Where do I keep, the deed to our house if we own a home? And then here's the institution where I have funds, or, because 20 years ago, someone passed away and we're like, oh, we'll just wait to get the mail. Well, I mean, if we don't even know what companies that your things are at, we don't know to contact that company because we have everything so online and email and all that kind of stuff. So I tell people, the phone, the laptop, and even just the email password, because a lot of times we will change all the internet passwords using our email, but we don't change the email password all that often. And again, you don't have to give it to them right now. On the location of important documents, you can say, whatever, in my top dress drawer on the left, I've got written down, these passwords or whatever, or look for a password list, or, that kind of thing. And I know there's all kinds of apps now with that you can give a rescue person or a emergency contact if they can prove that you're either incapacitated or you've passed. But we give worksheets too, and we were talking earlier about kind of co-executors and different things, but we give you some personal worksheets like, hey, burial and funeral instructions, do I or do not want to be, or do I not want, or do I want to donate to X charity? And I know as like a little bit younger, like we're not, and again, you could change this in the future, but we just give you that as a starting point of, hey, I want to convey, this information. And then also like, hey, who is my financial planner? Who's my CPA? What are some goals that I consider important for my kids or my family? Or what are some special instructions I want my spouse to know about? Or people write things about their pets. The neighbor really likes Fluffy. And so if anything happens, ask her first if she wants Fluffy. But it sounds kind of silly and trivial stuff, but the more that you can convey that information, and then, every few years, 5 years or every 10 years, you kind of update it because you have, a different pet, or, the kids are grown, they're in, different stages, college is over, or, things like that. So we do give to our clients those kinds of things, but there's no magical formula to that worksheet. I mean, you could make up your own, to keep. The legal documents are certainly the legal documents, but then with that, you want that personal, information and personal, instructions and that and preferences that you let those important people who will be handling this one day know, what it is that you are wanting them to do and what was important to you. What were your goals and your priorities, so that they know.
I wrote down treasure hunt, right? Like, it's like, that's what it could feel like to the people that you leave behind, because you're just literally like a detective trying to figure it out. And you just think about, like, you're already in an emotional state, right? The last thing you want to be trying to figure out is like, how do I get into like being on the phone, calling people, doing those types of things. And it's like, I think, I don't know how you feel about this, Wendi, but like, I feel like an estate plan is for, I mean, yes, there's the living part, right, of our documents, like a power of attorney and things of that sort. But like the afterlife stuff is for the people that you care about. It's not for you, right? And so making sure that your family can do it as easily as possible, as simple as possible. It's like a loving thing that we can do for our family, you know?
And that's what I tell people now too. And again, because we're so mobile and, we're more mobile than we've ever been, and then we're more internet based and different things. But as people are growing older and maturing in their life and kind of getting to that end stage, it's like, paring down on like the number of accounts that you have and the number of, I mean, I have these people that come in to do a probate and they're like, she had $782 in this bank, and then she had $50. But those are all places that someone, and it's to me, I mean, it helps the mental, clearing up. But you just would be surprised, like, why keep 17 different accounts. I mean, yes, we may want a few, because there are different reasons. One's a 401k, or one's an investment, or one's a checking and a savings, but like, don't have 6 checking accounts at 6 different banks if you don't need that. I mean, that's just not nice to people that are going to be trying to help you, figure this stuff out at some point. The other thing I will bring up, and this is probably going to be something later in life that people might want to think about, but when you update your estate planning documents, please, 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 please throw the old ones away. Because the
Okay.
treasure hunt that you just talked about, if I'm in mom's house and I'm digging around and I'm looking for a will and I find a will and it's dated
Mm.
2010, I'm not going to go, let me just keep looking and see if I find one for 2018, And so
Yeah.
they get this will and they're like, I have a will. And mom wrote a new will in 2018. Now one of my grandsons was a CPA and he'd be a better option to do the executor or whatever. And they didn't throw those away.
Mm.
And so I'll even file them for probate. And then 3 weeks later, they're like, hey, we did another will when we were cleaning up this and it's newer. And that's really, then I have to go back and fix, and do that. And so people are like, oh, I just kept all these No, like, keep the one that is the current, and just
That's it.
don't have older versions of things. Don't have account statements laying around your house for accounts you don't have anymore. Just throw it away, because then they're
That's
calling that
such
place.
That's such good advice, like, because I
Yeah.
know so many people that I think it comes back, and I mean, we don't have time or get into the whole, like, but, my grandfather's generation came from the Great Depression, and I do see a lot of that hoarding mentality. Hoarding of, like, physical things, and hoarding, like, what you're exactly talking about, like, financial statements, and just keeping years and years and years of statements. And so that's such a brilliant, like, of course that's what you do and you see this, but it's like I wouldn't have even thought to think about that, because yeah, we make changes and we keep old things because a lot of us think like, well, just in case, right? Like this idea that like somebody we might need it at some future point, right?
Right. Yeah.
Versus,
And so they found that old one, and it's not the one we want. And
yep.
yet somebody is now using something that we have, completely revoked, with this new one, because they stop looking. Once they find what they're looking for, I'm not inclined to go keep looking for 5 more of the same thing. So when we write new wills to people, I literally ask to bring the old ones and I shred them for
Mhm.
them. And I'm
Yeah.
like, this is the good one. We mark everything, but that's just something as life goes on, because when your kids grow older, then you may want to
Yep.
make them executor. And now you found this old will that had Uncle Tommy, and we don't need him to do it anymore because our kids are 30.
Yeah.
So those are just the kind of things that we see. And again, as a probate attorney, I'm like, even though I'm doing your estate plan, I'm going to tell you to do that because I don't want it to come up later as a problem in the probate.
Yeah.
So,
That makes perfect sense. Anything else that you want to add that maybe I haven't thought about to ask or
no, I mean, again, I think I would just stress. I know a lot of people are like, oh, I'm right, I will with AI, and I'm going to do this, and I'm going to do
mm.
that, and whatever. And I just see, even when I
You
look up
see
something
people
with
using
AI,
AI for estate planning right now too?
trying to write their power of attorney with it, or trying to, and then I'll even just, sometimes I'm googling something, and now you get that first little bit up there, it's some AI, and I am like, well, that's not actually the law. Like, looking up an attorney in whatever Wichita Falls, but I'm getting some other information about
Mhm.
whatever subject it is, and I'm like, oh no,
Yeah.
no, no, and so I think that it's like I said, just like I wouldn't use AI as a substitute for a medical examination for a medical problem I have, like, just, again, and it doesn't have to be this huge cost and all these other things. But when people have used that, so they can save, a few $100s now, the unintended result or the cost that they pay, somebody
Yeah.
to try to fix it, if it can be fixed,
Yep.
is in the thousands. So it's like, sometimes an ounce of prevention is worth a pound of cure. And so, just being prepared. And I mean, again, making your own plan. I think that that's just, it's so empowering to say, I'm going to decide, what is going to go on and who are going to be my trusted people in the future,
Yeah.
you know? So.
Totally. I I'm speechless because I'm like, I don't. I believe you. And I'm like, I don't believe that this happens. Cause it's like, yeah, there's just things that AI cannot replace. And that I believe it's like our knowledge and our wealth of experience, right? Years and years and years of experience. And like use AI for how to make, I don't know, cornbread or
How to
something.
write a
I don't
cover
know.
letter. Yeah, yeah, exactly. How to write a cover letter or for blah blah blah, or how to send a text to your friend that you really don't know what to say tactfully. Like
Yeah.
that's what I feel like. That's what those kind of things are for. But I hear more and more of it. People saying like, "Oh, I use this for that, and I use it to like try to write a deed or like something." And I'm like, "Oh no, don't do that." I
Yeah.
mean, because like I said, when I look at it, just in the AI suggestions, so many times, it's so incorrect, because it's a smattering of all kinds of different information. So
Yeah. Totally.
yeah.
Thank you, Wendy, for your time. Where can people find more about you, learn more about you, contact you if they're in Texas?
Sure. Yeah. So best place would be all of our information is listed on our website. So we are Heritage Law, and we do as well as estate planning and probate. I do handle adoptions. So we have done that for many years. We do some real estate transaction deeds, transfer and death deeds, things like that. But our website is just the Heritage Law TX. Got to remember the TX.com, and that'll have all of our contact information, information about the rest of our team. I'm not the only one there. There's a lot of other talented people at our office, which we love to serve people as a team. We feel like we're stronger as a team to help people. So yeah.
Okay, perfect. I'll put all of Wendy's information in the show notes. So thank you, Wendy, for coming on and sharing your knowledge with
Thank
us.
you for
And
inviting me. It
yeah,
was great to get to share and love what you're doing. So
yeah. And for each of you that are watching and listening, thank you.